Welcome to The Explainer. Look, if you're a worker, an HR manager, a small business owner, or an employer in India, you are definitely going to want to lean in and listen carefully today. The Supreme Court just dropped a massive labor law judgment about what exactly counts as an industry. And honestly, the headlines are everywhere and they are causing a lot of panic. People are genuinely confused, but hey, take a breath. We're going to set the record straight today with just the facts, breaking down exactly what you need to know without all the legal jargon.
You know, you might be facing a situation right now that looks a little like this. Picture it, your boss comes up to you and says, yeah, you're actually not covered by labor law anymore. You jump online, frantically search the news, see a bunch of scary headlines about a brand new Supreme Court test, and suddenly, everything feels totally uncertain. It's like the ground beneath your feet is shifting.
Okay, let's dive right into this. The big million-dollar question on everyone's mind, and probably yours, is simply, have my rights just disappeared? Well, the short answer is no, absolutely not. But, and this is a big but, there is a highly specific legal distinction and a really crucial date that you absolutely have to understand so you don't fall into a legal trap.
Section 1, the 1978 Triple Test. Understanding the old rules.
So to get why everyone is freaking out today, we actually have to rewind a bit. We have to grasp how the old Industrial Disputes Act of 1947 worked, because it literally laid the foundation for this entire conversation. Back in 1978, the famous Bangalore water supply judgment created what the legal world calls the triple test. Basically, for a workplace to count as an industry, it had to tick 3 boxes. 1, systematic activity, meaning casual one-off side gigs didn't count. 2, there had to be cooperation between the employer and the employee. And 3, this whole setup had to result in producing or distributing goods or services for human needs.
Now, here is where it gets really interesting. Under this old test, making a profit? Completely optional, the test was incredibly broad. Think about a massive hospital. You've got doctors, nurses, cleaners, admin staff, all working in this highly organized machine to help patients. Under that old 1978 approach, just because that hospital wasn't driven by profit didn't mean it wasn't an industry. This meant the law ended up covering a massive range of organizations, way beyond just your traditional smokestack factories.
Section 2. The 2026 Court Judgment, State of UP versus Jaiber Singh.
Fast forward to August 2026. A massive 9-judge Constitution bench looks back at that super broad definition and says, actually, let's reformulate this. They added a requirement for a commercial character. In plain English, the activity now needs to resemble a trade or a business. The court basically rejected the old mechanical checklist approach, saying you have to look at the true nature of the activity and the total circumstances.
And boom. This right here is the exact tension driving all those scary headlines. Left side, the 1978 broad approach, no profit motive required. Right side, the 2026 formulation, which demands a commercial character. Employers are pointing at this new requirement and arguing, hey, without a commercial character, you workers just lost your coverage.
But wait, here is the giant trap that everyone is falling face first into. This 2026 reformulation does not automatically govern pending old law disputes. Let me say that again. The Supreme Court explicitly stated that if you have a proceeding already pending under the old Industrial Disputes Act, you keep using the older 1978 framework. The new rule is prospective. It absolutely does not erase the rules for disputes that were already chugging along in the pipeline.
Let's map this out on a timeline because the dates are literally everything here. 1978, we get the old broad test. Decades pass. Then, November 21st, 2025, the totally new labor code is enforced. Then, and this is why it's so confusing, on August 2026, the Supreme Court issues a judgment on the ALD Act. You're probably thinking, why are 9 judges in 2026 ruling on a repealed 1947 law? Well, because courts still have to resolve old, backlogged disputes. But for the future, for any new matter happening after November 2025, we are operating in a totally different legal universe.
Section 3. The new labor code and the current landscape.
Because for any workplace matters arising after that November 2025 date, that old law is gone. We now look at Section 2P of the Industrial Relations Code 2020. This is the new, shiny statutory definition of an industry. It still looks for systematic activity, it still requires employer-worker cooperation, and it still covers producing goods and services. And importantly, just like before, capital investment or profit doesn't automatically make or break the definition here either.
But here's the curveball. The new code comes with a VIP list of express exclusions. It totally carves out certain charitable institutions, social and philanthropic groups, sovereign government functions, and domestic service. The central government even has the power to add more exclusions later if they want to. So today, you have to examine these exclusions really, really carefully.
So, and I really want to stress this, it's so important. That massive 9-judge Supreme Court judgment, it did not decide the meaning of Section 2P in the new code. You cannot just copy and paste a 2026 ruling about an old repealed law into a modern, post-2025 dispute. The Supreme Court was super clear that the new code has to be interpreted completely on its own, based on its own specific wording.
Section 4. Which rule governs you?
All right, this gives us a definitive fork in the road. This is the practical solve. You basically have to sort your situation into one of two buckets. Bucket 1, are you dealing with a pending old law dispute? If yes, great. Use the 1978 Bangalore Water Supply Framework. Bucket 2, is this a totally new matter happening under the new code? Then you use Section 2P and meticulously check those express exclusions we just talked about. It really is that straightforward.
So, to all the workers tuning in, please do not assume your coverage is just magically gone because of some water cooler gossip about a new ruling. First, systematically identify which legal regime actually governs your workplace. Ask yourself the exact date and nature of your dispute before you make a single assumption about your rights.
And for the employers taking notes today, do not tell your workers that the Supreme Court just blanket narrowed all labor rights. That is legally inaccurate, and frankly, it's just wrong. The 2026 judgment explicitly preserves those old frameworks for pending matters. And for the new stuff, you have to evaluate the new code separately.
So the next time you hear someone panicking about this ruling, remember this absolute bottom line question. Is my dispute governed by the old Industrial Disputes Act or the new Industrial Relations Code? Because at the end of the day, it's not about the scary headlines, it's entirely about correct legal classification. Which leaves us with a pretty massive cliffhanger for next time. If the new Industrial Relations Code does govern your workplace, exactly who counts as a worker now, and what remedies can you actually claim under this totally new regime? That is a huge topic on its own. Listen, if this explainer helped cut through the noise for you today, make sure to subscribe for future insights where we break down the practical realities of the law, totally free of courtroom jargon. Thanks so much for learning with me today.